Okay, so the wait is finally over. The Protection of Personal Information Act is finally here. That went live on the 1st of July 2021. So, but as you all know, POPIA is quite a big thing in South Africa right now in terms of the information officer and what can we do and what can't we do. So today, that's what we'll be talking about, the Protection of Information Act, also known as POPIA. Today, we will be joined by the Norton Rose Data Privacy Team, Rosalind and Ushenta, Naidoo, who will explain the roles and responsibilities of the information officer and how to comply with these requirements. So welcome to Rosalind and Ushenta. I think it might be a bit of an uncertainty at the moment for POPIA and for a lot of us and our brokers in the industry. So hopefully you'll be able to clear any questions that we and our brokers have today. So yeah, I'd like to hand over to you guys and looking forward to the presentation.
Thanks so much, Stephen. Hello, everyone. I can't say I'm going to answer all your questions, but I hope that will give you some guidance. We've actually got quite a lot to get through today, so we're going to kick off. You're welcome to put questions in the chat, and we'll try and get to them during the hour. But you know, just as being an information officer is a big job. It takes a bit of time to explain what those roles are. So what we're going to talk about today, you know, we're not going to go through the nitty gritty of POPIA and, you know, the 8 conditions and everything that people have heard before. What we're going to talk to you about is what does someone who is against their will or otherwise appointed as an information officer, what is it that they have to do in terms of POPIA and what are those requirements? So I mean, the wait is over. POPIA has now been enforced for almost a month. The information regulator's registration portal is still not fixed, almost a month down the line. But certainly, you know, we are seeing things settle down a little bit after we saw all the very entertaining memes about POPIA coming into force. But certainly there is still a degree of uncertainty. There have been some very weird interpretations that people have taken. And you know, still we're finding that a lot of people don't understand exactly what it is that POPIA is all about. So, you know, just to be clear, it is not the sort of thing where you just need a POPIA clause to stick into your agreements, as much as that would be a great way to solve the problem. Just to reiterate what POPIA applies to. So it relates to processing of personal information, which I'll get to in a second, where the responsible party is either domiciled in South Africa or the processing happens in South Africa. So that means, you know, I'm sure all of you on the call have already established that it applies to your operations, and it applies to personal information that forms part of a record. So either that you process electronically, so using automated means, you know, for example, recording this particular session, we are processing personal information, or using non-automated means. So that means if you have a filing cabinet or, you know, any other form of, or you shred documents, those are all going to be processing activities covered by POPIA. So let me take you through some key concepts. So to just understand and to reiterate, the whole point of POPIA is to protect privacy of data subjects. They're called data subjects, so it's the person to whom information belongs. So all the time you should be thinking, is what I'm doing with the information that I get from my clients and insurers and service providers, am I respecting the privacy of that information in the way that I'm using it? Do people know what I'm doing with it? Am I transparent in what I'm doing? And am I using it for what I tell people I'm going to use it for? And there are a whole lot of measures in POPIA that are designed to protect the privacy of information. And the reason being is that personal information really is the currency of the future. It's unbelievable what you can buy personal information for on the dark web. I mean, we deal with cyber incidences on a weekly, we had 2 this weekend, And personal information is extremely valuable for cyber criminals, in essence. And you know, even hackers even sell, they call it real estate. Once they've got into someone's system, they will sell it to another hacker who will come in and use that information. So, you know, it's really about protecting your organizational risk. It's about making sure that your name doesn't get splashed on the headlines for not taking people's privacy seriously. So there are two categories of personal information. The first is what we call kind of general personal information. And that's really what you typically think of. It's anything that can identify someone. So the key thing about personal information and what makes it personal is that you can use it to identify someone. If you can't figure out who that information belongs to, it's not personal information. So when we're talking about personal information, generally it's, you know, it's contact details, email address, you know, name, photos, ID number, browsing history, opinions, and private correspondence. So it's typically, you know, what you would normally think of in terms of someone's personal information, something you can use to identify them. Then you get a different category, which is called special personal information. So this is information that is even more valuable, and there's a greater degree of risk to someone if that information is compromised. So as an example, you know, someone's health information, if they had you know, some sort of cochlear implant, for example, someone could remotely manage that. So there are degrees of what can happen with someone's information and why you've got to keep it safe. And special personal information and also information of children. So anyone under 18 is given like an extra degree of safety. You have to jump through a few more hoops to make sure that that information is kept secure and that there's no risk to the data subjects. So when you're thinking about this as an information officer, you have to have oversight of all the information that you're processing in your organization. And it's really important to categorize that information as, is this just ordinary personal information? Is it financial information, which could cause you know, harm as well, but it's not special personal information? Is it special personal information or information of children? And then, of course, South Africa is fairly unique. There are a number of African countries that seem to be following suit, but fairly unique in protecting the personal information of corporate entities as well. So that means that obviously a corporate can't be pregnant, can't have health status, but it can have a criminal record, it can have a financial information and identifiers. So it's really important to have a good grip on what information you have, the degree of risk to the data subjects in processing that information, and understanding the categories that you have. Rule of thumb, though, is can information be used to identify a human or a corporate entity? And if so, it's personal information that needs to be protected in terms of POPIA. Okay, so I've also used this term processing. So processing is a very broad concept. It pretty much covers anything that you're going to do with personal information in its life cycle through your organization. So from the minute you collect it, or even think about collecting it, transfer it to someone else, access it, merge it with another document, delete it, destroy it, record it. Anything that you do with personal information of this nature is going to be called processing. And when you process personal information, POPIA kicks in with 8 basic minimum requirements that you need to go through to make sure that you are protecting the privacy of that information throughout the time that you are responsible for it. Okay. So talking about responsible, there are 2 categories of parties that are contemplated under POPIA. The first is the responsible party. So they are the one that controls the procedures and purpose of processing of personal information. Now, it's a little bit of a tricky one when it comes to the insurance sector because, you know, there's been a lot of debate, well, a lot of people are debating about where where a broker is a responsible party and where they're an operator acting on behalf of a responsible party. And it seems to us that there are going to be many circumstances where a broker and an insurer are actually going to be joint responsible parties, because they both individually determine the procedures and purpose and how they process personal information, even if it happens to be the same personal information, relating to particular insureds, as an example. Now, the thing about POPI, as opposed to GDPR, for example, the European equivalent law, is that there is very limited separate liability for an operator under POPI. So a responsible party is what it says it is. They're the ones who carry the can for everything. So they've got a whole lot of obligations, whereas an operator who is processing personal information under the mandate or authority of a responsible party only has, three very limited obligations. So they can't process personal information without the knowledge of the responsible party. They have to treat it all as confidential, and then they need to notify the responsible party if there is a breach. So what POPI says, you've got to have a written agreement in place with anyone who processes personal information on your behalf. Really important to clarify here is that we've seen a lot of people who just want to have agreements in place when they just have relationships with one another and they need to use information for that contract. That's not appropriate. Where an operator agreement comes into place is where someone is literally processing on your behalf. So, if you use a shredding company, if you're using a cloud platform, if you use a payroll administrator, these are activities where someone is processing personal information on your behalf, as opposed to, for example, when you give personal information to your auditor for them to carry out an audit, that is not them processing it on your behalf. That is them using personal information as a responsible party to carry out their performance obligations for you. So this is really important as an information officer to understand what your role is in relation to any personal information. Because remember, you're going to have a situation where if there's a breach, you need to know, are you responsible for that information or are you processing it on behalf of someone else? Ultimately, who is liable? Really, that is the question. So really important that you do have written agreements whenever anyone is processing on your behalf. I see a question just popped up saying, do we need to have agreements with brokers? In some circumstances, you will, where they are acting as on your behalf to process personal information. But in many instances, we think that brokers and insurers are going to be joint responsible parties. So you don't have to have a written agreement. POPI only says that when people are operating on behalf of one another. But a lot of people want to do that for good practice in terms of having a data sharing agreement so that you know who's responsible to deal with a data subject access request or who reports to the regulator. But it's not essential. You will have to look on a case-by-case basis. Then just in terms of enforcement, what are the consequences for non-compliance with POPI? Is they're pretty extensive. We haven't seen the regulator imposing any fines this month yet, but watch the space. So I think something that's really important for everyone to understand is it's not only regulatory action that can follow for non-compliance with POPI, is that you are, as a responsible party, liable for any harm that comes to a data subject as a result of your processing of their information. So whether it was not compliant with POPI or whether there was a breach or a security compromise, they still have a claim and they don't have to prove fault. So it's in essence strict liability. So that's why it's super important to make sure that you are doing everything that you can to mitigate that risk. Then, of course, you do have enforcement by the regulator. They've got a whole range of things they can do, including things like dawn raids, search and seizure operations, proactive investigations, and they can send you various notices to say either, you've got to fix this practice, or you've had a complaint, or we're going to impose a big penalty on you, or we're going to refer you to the National Prosecuting Authority. So we wait to see how the regulator is actually going to enforce POPI, but the penalties can be up to 10 million rand, and criminal consequences, depending on the particular contravention, can be up to 12 months in jail or 10 years, which is really significant. There are separate liabilities under POPIA, the Promotion of Access to Information Act, which we're also talking about this morning, because the information regulator is now the regulator over both POPI and POPIA, which used to fall under the Human Rights Commission. And this means that they're now tasked with ensuring that everyone complies with POPIA as well. So as an information officer, you have a dual role under both laws. So I'm going to hand over to Ushenta now, who's going to take you through some of those responsibilities of an information officer.
Thank you, Rose. So first up, we're going to deal with who qualifies as an information officer, and this slide deals with the identity of the information officer for the different types of private bodies. However, we'll only deal with the last category, being juristic persons, as this is the most relevant. So the CEO, managing director, or equivalent of an organization or their appointee is, by virtue of their position or appointment, the information officer. The CEO or MD or equivalent can authorize any natural person within a body to act as the information officer. And it should be noted that the guidelines published, or that there are guidelines rather, that have been published by the information regulator, which deal with information officers and deputy information officers. And these guidelines provide that the person authorizing another to act as the information officer remains accountable and responsible for the power or function that has been authorized. However, we're not certain if this is actually correct in law. As Rose mentioned, both POPI and the Promotion of Access to Information Act, known as POPIA, deal with the roles and responsibilities and appointment of information officers. Now, neither POPI nor POPIA requires any specific qualifications in order for a person to be appointed as an information officer, and the guidelines published by the information regulator recommends that the person appointed as information officer be at an executive level position. And it's our suggestion that the information officer be someone who has a broad understanding of the organization's operations and processing activities, or at least someone who has the capacity to learn about the operations of the organization and its processing activities. Moving on to registration, an organization as the responsible party must register its information officer with the information regulator before the information officer can commence their duties in terms of POPI. And the information regulator had previously announced that information officers were to be registered at the end of June. However, in a recent media statement, the regulator did announce that there will be no deadline for the registration of information officers. And this is due to the technical glitch that Rose mentioned with the online registration portal. The registration can be done manually or through the online registration portal when it is up and running again. And the portal is available on the information regulator's website. And from our experience, when the portal is up and running, registration is a relatively quick process and shouldn't take more than 15 minutes or so. Alternatively, you can complete the manual form, which is available on the regulator's website, and email it through to the regulator. Prior to registering with the information regulator, the information officer should be duly authorized to act as the information officer. And this authorization can be done by way of corporate approvals, such as board resolutions, or by way of an organization's internal approval or authorization procedures. And this form of authorization must be in writing. The information officer guidelines provide a template form which can be used for the authorization. However, you can draft your own authorization so long as the wording is substantially similar to that of the template. And any authorization made does not prevent the person who is making the authorization from exercising the power or duty concerned. And this authorization can be withdrawn or amended in writing at any time by the person who initially gave the authorization. The information officer guidelines stipulate that the information officer must be based in South Africa for accessibility purposes. And this means that for multinational organizations based outside of South Africa, they must authorize a person within South Africa as the information officer. Additionally, each subsidiary of a group of companies must appoint an information officer and register its information officer and deputies with the regulator. And from an accountability perspective, we would also recommend that a formal appointment letter is drafted, which sets out the roles and responsibilities of the information officer and what is expected of them. Sorry, I missed this slide. Moving on to deputy information officers. Information officers may delegate any of their powers or duties to deputy information officers, provided that they are in control of the designee's activities. It should be noted that it is not a requirement to appoint deputy information officers. And deputies may be appointed at the discretion of the organization, and the number of deputies appointed will depend on the size of the organization and the complexity of the operations or processing activities. POPIA requires organizations to designate as many deputy information officers as necessary to assist information officers in performing their duties. The information officer guidelines stipulate that only employees of an organization can be designated as a deputy information officer. Any designation to a deputy information officer must be in writing, and any delegation of power or duty must be in writing. The information officer guidelines provide a template again, which can be used to delegate powers or duties. And again, you can choose to draft your own delegation so long as the wording is substantially similar to the template. Despite any designation or delegation to a deputy information officer, the information officer remains accountable and responsible for the functions that are delegated to the deputy. Once again, to ensure accountability, the information officer guidelines recommend that any delegations of power or duty to deputies are included as a part of their job description, and we would recommend that a formal letter be drafted detailing the designation of the deputy and outlining their responsibilities and duties to ensure that there is transparency and understanding regarding what is expected from them. Just to take you through the roles and responsibilities of an information officer. The information officer's primary responsibility in terms of POPIA is to ensure the organization's compliance with the conditions for lawful processing of personal information. And before jumping into a detailed explanation of the roles and responsibilities, we thought it would be beneficial to give you a quick high-level overview of what is expected of an information officer. The information officer bears the responsibility for the personal information being processed by the organization, and they must know what personal information is in the organization's possession or is collected, where the information is stored, the purpose for which it is collected, how the organization uses the information, and they must also have a comprehensive knowledge of POPI and all of the requirements which apply to the organization. POPI sets out the following duties listed in front of you for information officers. And information officers must encourage compliance with the conditions for lawful processing. And this is a sort of overarching responsibility as it ties together all the responsibilities of the information officer and the role that they play. The information officer needs to establish an internal process to deal with data subject requests made in terms of POPI and PIA. There needs to be a process in place to record all requests and log the responses given. For example, whether information was corrected or deleted, or if a data subject was provided with a particular record. This needs to be done for internal record keeping purposes and in the event that you are required or called on to report to the regulator on data subject access requests. The information officer needs to be well versed in the organization's processing activities in order to work together with the regulator in relation to any sort of investigations that may occur. Regulation 4 of POPI imposes additional obligations on information officers. They have a positive obligation to ensure that a POPI compliance framework is developed to monitor and maintain compliance. And they also have an obligation to ensure that personal information impact assessments are conducted for every processing activity that an organization engages in. And Ros will take you through this in a bit more detail later on. In terms of PIA, public and private bodies must publish manuals stating the data subjects on which the body holds information and the types of personal information held. And the manual must also specify the availability of the records and the manner in which they may be accessed. Information officers bear the responsibility of personal information being processed by the organization and must ensure that regular trainings such as this dealing with the provisions of POPI is held. And that training should also involve any recent communications with the regulator or the guidelines or codes that are published by the regulator, which may be relevant to the organization. The guidelines that I've been referring to provide further responsibilities for information officers. And it is recommended that information officers and deputy information officers receive appropriate and regular training to ensure that they are up to date with the latest developments of POPI and PIA. And the guidelines also advise that should there be any change to the details of an organization's information officer or deputy information officer, the relevant details should be updated at intervals of no more than once a year. The details of an information officer or deputy in the organization's PIA manual must be the same as the details provided to the regulator. I have previously mentioned reporting to the regulator, and Ros will take you through this in a bit more detail later on. Moving on to liability, POPI empowers the enforcement committee, which is established by the regulator, to take any recommendation to the regulator which is necessary or incidental to any action that should be taken against an information officer in terms of PIA. An information officer may, on conviction, be held criminally liable in terms of PIA if they, with intent to deny a right of access in terms of PIA, destroy, damage, or alter a record, conceal a record, or falsify a record or make a false record. An information officer who willfully or in a grossly negligent manner fails to comply with the provisions of POPIA relating to the POPIA manual or retention and restriction of records on conviction may be held criminally liable. An information officer can also be held criminally liable for non-compliance with an enforcement notice. And the penalties for these offences range from a fine or imprisonment not exceeding 2 or 3 years, depending, of course, on the offence committed. Monitoring and compliance. As mentioned earlier on, an information officer must establish a compliance framework to monitor and ensure compliance with POPIA. In establishing a compliance framework, the information officer will need to think about what measures they can implement to monitor and ensure compliance. For instance, will policies be developed to ensure compliance? And if so, what policies? How often will the policies be reviewed and updated to ensure that they are still in line with any developments that may occur in terms of POPIA? Will data flows be created to understand how information flows through an organization? Or will each department within your organization complete checklists to understand what personal information is processed and how each department handles that information? Are you as an information officer aware of the information processed by each department within your organization? So to ensure such processing is in line with POPIA. Is each department familiar with the organization's policies regarding personal information, and have they received the relevant training to familiarize themselves with the provisions of POPIA and the organization's internal policies? You will need to ask yourself questions such as, are your employees familiar with the consequences for non-compliance with POPIA in terms of the Act itself and in terms of internal policies or procedures? And has your organization considered what steps or actions will be taken if non-compliance with POPIA is identified? And furthermore, have your employees been made aware of these steps? The information officer must ensure that the organization has a POPIA manual and that the POPIA manual is monitored, maintained, and made available in accordance with both POPIA and POPIA. It is also a responsibility of the information officer to ensure that internal measures are developed together with adequate systems to process requests for information. The information officer has been assigned with the task of receiving and coordinating all requests for access to records in terms of POPIA in order to ensure compliance with both POPIA and POPIA. A data subject who has provided adequate proof of identity has the right to request access to the personal information that a responsible party holds in relation to them. The way in which requests for access to personal information under POPIA must be made is set out in POPIA. And requests for access to information should be made in the manner prescribed by the organization in its POPIA manual. In terms of POPIA, data subjects also have the right to request the correction of their personal information, and Ros will deal with this in more detail later on. Just to note that POPIA has amended what needs to be included in a POPIA manual and requires additional information to be included in the manual, such as the purpose of the processing of personal information, a description of the categories of data subjects, and of the information or categories of information held relating to the data subjects, the recipients or categories of recipients to whom the personal information may be supplied, any planned transport of flows of personal information, and the manual must also include a general description of the information security measures to be implemented by the responsible party to ensure the confidentiality, integrity, and availability of the information which is to be processed. An organization's POPIA manual must be made available on its website, at its principal place of business, to any person on request and upon payment of a reasonable amount, and to the information regulator upon request. I will now hand you over to Roz, who will take you through the remainder of the roles and responsibilities of the information officer.
Thanks, Ushenta. Okay, so one of the most sort of significant things about POPI, or what we've seen happening in GDPR and others, is often with other regulations, you wait for someone to have a complaint or something. But under POPI, there are a whole lot of reasons why data subjects would interact with a responsible party. And that's because they now get a whole lot of rights that they didn't previously have. And certainly, I mean, personally, I'm really pleased about this because I think there are a lot of parties who have my information and I'd rather they didn't, or I'd like to know where it came from. So I have what are called data subject requests. They sometimes you'll see references data subject access requests, so DSARs. And this is basically saying that as a data subject, you have a right to know what information someone has about you, what they're using it for, and if it's inaccurate, to have that corrected, or to ask for it to be deleted or destroyed. So this means that as an information officer, you have to have a very good idea of what information you have about which data subjects, because you have only 30 days to respond to one of these requests. So, if someone says, I want to know all the information you have about me, you need to be able to pull that together pretty quickly and also assess it to see whether it's information that you will be providing to them or if you'll hold back for any of the reasons permitted in PIA. So it is something that is a big part of the information officer's job. There we go. Okay, so there are certain grounds on which requests can be rejected or partially refused. These are set out in PIA. So these include things like legal privilege. So if it relates to any legal advice, you're not required to disclose that. If the disclosure would be unreasonable, if you would have to breach your own contractual confidentiality to do that, if it would disclose trade secrets or commercially sensitive information. And lastly, if it would cause serious harm to a data subject's physical or mental health. So, it's important, for example, if you're interviewing someone for a new job, and you're taking notes about them, make sure that you don't say anything that you don't want to then have disclosed to them, or anything that might, harm someone's health. But in essence, that means you're going to have to be, one, able to pull up all these records, and two, assess them to see what grounds you have to refuse disclosure or to provide the disclosure of the information they've requested, and also to have mechanisms or systems in place to redact certain information. So, you don't have to provide a complete record, for example. So it's really important to just have that process in place, because we are seeing what happens in other countries, and here will be a bit different as well because it deals with juristic persons, is that these requests are often used just before someone is about to launch litigation. It's used as a way to get additional information from a responsible party. So they are used quite frequently, and it's something that you're going to have to be ready to manage. Yeah. Okay, so the information officer is essentially the face of the organization when it comes to the information regulator. Now, there's one particular ground that is specified in POPI where the information officer has to engage with the regulator in an investigation. And this relates to applications of prior authorization. So there are certain situations where POPI identifies particular types of processing that they see to be high risk and parties can obtain prior authorization for that processing. This has been postponed until February 2022. We think that the regulator was just absolutely inundated with requests for prior authorization, and so they postponed the implementation of that section to next year. But if one were to make such an application, it's fine, you can go to the next slide. If one were to make such an application, you as an information officer have a responsibility to engage with the regulator kind of fully and truthfully. Then for a public body, so it's not for a private company, but public bodies are required to keep full records of all of the requests received in terms of POPIA and POPI. And the information that needs to be retained is how many requests you've received, which ones were granted, which ones were denied, why were they denied, and which ground of POPIA was relied on. So, was it a legal privilege or, commercial trade secrets? Now, you don't have to, as a private organization, you're not obliged to keep these records. We would recommend, however, that you do so, because the regulator can obviously ask for it at any time. And it's also just important from a record keeping perspective, because you also want to make sure, particularly for things like when someone objects to processing, or someone withdraws consent, or any of the other rights that they might want to exercise, you have to make pretty sure that your records are updated and keep a record of what the outcome was. Because if someone's unhappy with your decision to not grant them the information, they can go to the information regulator and have that process reviewed or appealed. So it's good to keep a record, particularly for succession planning. The information officer might not always be the information officer. And so really, we recommend that you keep a full record of these requests, obviously limiting access because they do contain personal information. Yeah. All right. So the next requirement, which is probably the one that is the most sort of onerous or can be quite challenging for information officers, is what's called a personal information impact assessment. Now, this is really about ensuring that any processing activity that you're going to embark on is compliant with POPI, and that you've taken privacy into consideration in the way that you structure whatever it is that you're doing. So the first point, obviously, Ushenta took you through, is you need to, as an information officer, you need to have oversight of all the information flows within the organization. And you need to have done that assessment of, can I lawfully process this information? What's the basis on which I'm processing it? Have I told people I'm processing it? Have I put security measures in place? And when it gets to a personal information impact assessment, it's again, just making sure that before you embark on any new processing activities, that you've assessed its compliance with POPI. So we would recommend that you do a personal information impact assessment if you've got a new project or if there's a major change to an existing process. So as an example, in the Netherlands last year, there was an organization that had to pay a penalty of some 200,000 euros just because they could not demonstrate that implementing a biometric fingerprint access system to their company was a reasonable limitation on their employees' right to privacy. And the reason being is that they had not done a personal information impact assessment, and they hadn't weighed up whether their security needs trumped, or their monitoring of their employees, productivity or whatever it was, had trumped the risk of keeping a database of someone's biometrics. So I've seen a question. We have already confirmed with the IT team that the presentation will be made available. Okay, so then just in terms of how to comply, we'd recommend that you have sort of a template of those questions you need to ask. If we go to the next slide, there is, we've provided a link for the UK information, it's in the next one, but we have provided a link for the UK information regulator. They have a wonderful set of resources. Although it's based on GDPR, we don't yet have one for POPI, so it is useful to have a look at that. So I'm going to go back now. Sorry, Ushenta, I'm making you jump all around today. So when you're doing a personal information impact assessment, these are the steps that you need to go through as an information officer. And I would also encourage you to make sure in your compliance framework that your staff know that before they do something that involves personal information that they're not already doing, that they've got to escalate that to the information officer, and they're not allowed to do it until you give them your seal of approval. And that's really important to have that escalation process in place. And the ability to take disciplinary procedure if someone does procedures if someone doesn't comply. So you've got to look at these kind of things. So what is it? What is the personal information that you want to process? What does it involve? Keep a record of this. Is it going to be electronic? Is it going to be manual? Are you going to use an operator? What kind of information are you processing? Is it highly sensitive? Not so sensitive? How many data subjects are involved? Does it involve children? Does it involve cross-border transfer? And then you need to ask, why do you need this information? So it's really important. You've got to ask all of these questions to make sure that the processing is justified and compliant with POPI. Go to the next slide, please. Then you need to make sure, who are we dealing with? Who within the organization is managing this? Is it procurement or sales, or, is it a direct marketing campaign? So then you need to look at the risk. So what is the risk and nature of the impact on data subjects? Now, it's important to understand that, under GDPR, which is what a lot of, POPI is actually based on GDPR's predecessor. So there's a lot of similarity, but there are some differences as well. But when it comes to personal information impact assessments, one can quite usefully rely on that. But the important thing is that under GDPR, there's a risk threshold. So they're more concerned about information that is breached or impacted that is going to have a high degree of impact on data subjects. Unfortunately, we don't yet have that from the regulator. So pretty much any compromise needs to be notified, and all processing activities need to be assessed in terms of personal information impact assessments. So you've got to go through those steps and then make a call as the information officer on whether that processing should go ahead, or whether the information, whether there needs to be any conditions imposed on that processing. Okay. Okay, and then the last requirement that an information officer is in charge of is ensuring training. So the regulations to POPI require an information officer to carry out awareness training. And in fact, it's really useful to know is that when we notify breaches in other jurisdictions, because we don't yet have our form here in South Africa, one of the questions that's asked is, when last did the particular employee implicated in a breach, when did they receive training? And it's something that is a positive obligation on you to ensure that there is training. So the training needs to be on the provisions of POPI and what it means for lawful processing. If you have any internal policies that they need to follow in terms of, what are your rules for keeping information secure? Also, obviously, it's best practice to make sure that your employees are trained on any policies so you can take disciplinary action for non-compliance. Also, if there are any applicable codes of conduct, if there's any communication from the information regulator that affects you directly, you are required to make sure that your staff are made aware of that. So really important that you have regular training, that you keep detailed records of attendance at that training, because it is something that, you know, when you are audited for compliance, you know, it's often the things that will come up is whether people have been trained. And we would certainly recommend that you make any training compulsory, because it is a legal obligation on the information officer to make sure people are aware. And I just want to say is, I mean, yes, it's a tick box, you know, you have to do training, but in fact, training is one of the most effective ways to mitigate your risk. So employees need to know what they can and can't do so that they can comply with the law. And even though, you know, there's strict liability, or you might still be found liable under the Act, the fact that you took all these steps to train people, you've got an extensive compliance operation, all the rest of it would certainly mitigate any penalty. So it really is very important, the training aspect. Okay. Then just so some things to think about. I mean, it's a lot. It's a lot to take in. There's a lot to be done as an information officer. So these are sort of the high level, you know, what you do need to be doing if you haven't done it already. Obviously, there's a challenge with the registration, but, you know, have you figured out who your information officer is? Have you got your deputies? Have you appointed them by board resolution, or have you got a delegation letter in place? Then have you got a POPI compliance framework in place? Do you have a way to monitor compliance? Do you have systems in place to ensure that staff questions are escalated appropriately? Do you have a central point that someone can submit data subject access requests? Do you have a system, or, you know, have you identified who your operators are? So, you know, if someone says to you, who's processing my information, you need to know very quickly that it's, you know, you've sent the information there, or it's being used here. You've got to have a pretty good grip on all of that. And then your POPIA manual, do you need one? Have you checked? If you have one, has it been updated to accommodate POPI? So there is there has been an extension of the exemption for POPIA manuals until the end of the year. But it is still, you know, incumbent on you to assess whether you require one. And if you do, then it must be displayed on your website and so on, as Ushenta mentioned. Then you need to make sure that you have personal information impact assessments in place. In an ideal world, you should have done one for each of your ongoing processing activities and keep a record of you know, the measures that you've adopted to mitigate any limitations on privacy. But you've, at the very least, must have procedures in place to do such an assessment for each new processing activity. Make sure that you have you know, a system in place so that that doesn't fall through the cracks, so that people don't start new activities without getting the necessary approval. And then lastly, of course, just mentioned internal awareness sessions. Obviously, you know, by attending this session, you are already you know, getting some information and training, but it is important to make sure that internally within the organization that your staff know what POPI is about, know what they have to do and not do. And that's really going to be your biggest risk mitigator, because I can tell you, you know, in the data breaches that we respond to, which are many, there are, yes, hackers are, you know, the main cause of many cyber incidents, but a lot of that comes from poor cyber hygiene of employees feeling very vulnerable economically and falling victim to phishing mails, which are becoming increasingly sophisticated. You know, there are so many ways, but even so, we also see a lot of breaches where, you know, someone unlawfully downloads a whole lot of information just before they leave the organization, either, you know, to set up their own brokerage or whatever it might be that they're doing. or people sell information. When you think about the fact that a medical record is available on the dark web for up to $1,000, that's a very big incentive for someone to sell. So it's really important that you've got to limit access, make sure that people don't have abilities to download databases and so on, and make sure that your employees are very trained and aware of the negative disciplinary consequences that may flow from their non-compliance, because that's often what trips people up. And that is about that, I think. Got a few minutes. I see there are other questions that we might not have dealt with.
Ros, there is a question from Rika. Rika has asked if information is available publicly, for example, a company's registration number, is this still identified as personal information?
Oh, there's always someone who asks the tricky question. So, okay. So this is a bit of a difficult one. And we actually asked the information regulator directly because it's weird because it's public. So why do you then have to protect the privacy of it? Now, the challenge is that it still constitutes personal information, but it's very low risk, because it's publicly available. It's been made deliberately publicly available. However, you do still have a notification obligation. So if you are going to be collecting someone's company registration and director's information and so on from CIPC, for example, it should be contained in your privacy policy. You should say that, we collect information from publicly available sources such as whatever, and we will process that information. Because the fact is they still need to know, if perhaps their information is inaccurate, it's been collected from publicly available sources, and you're making decisions based on that information. It's important for people to know that that's where it's coming from. So obviously in circumstances of a breach, that's going to be less problematic because it's already in the public domain. I mean, unfortunately, the regulator's response was, oh, it's all treated the same, and you must just be careful about what you disclose. So I'm afraid that's not, it is a bit of a weird one to get your head around, but it's really about what you use it for. And my rule of thumb is no one should be surprised about anything you're doing with their information. So if you've told them, even if it's just in your privacy policy, then it's incumbent on them to say, okay, I'm not comfortable with you using my company registration number for that purpose.
Okay, perfect. And then we've also been asked by one of our partners to password protect our policy schedules going forward. Is this something that you believe that we should be doing constantly, or is it for them just a safety precaution that they're looking at?
So it depends on the security of your email server and what kind of measures and protections you have in place in any event. Each organization has to make a call on what they think are the most appropriate security and organizational measures. I must tell you that the gold standard and the thing that is going to protect you from breaches most of all the stuff is multi-factor authentication. So if you are managing access to your emails through MFA, you're in a much better position than just sort of encrypting or password protecting. I mean, I do think that, you do need to think quite carefully about it because often it's you might have all those measures in place, but what about the recipient? And that's where people start saying, okay, well, I don't need an operator agreement, but I'm going to be sending you a whole bunch of children's information. I'm not comfortable that you're going to keep it safe when it gets to your end, and I don't want to have that coming back to me. So when you do that, you should password protect. I mean, I think I would always rather be overly cautious than under. If it's possible to simply, do a simple password, well, not too simple, always use a complex password, but to password protect something that contains, because I mean, a policy schedule can contain pretty detailed information, and any measures that you can take to limit that will will mitigate exposure and protect the privacy. So recommended, but again, you know, POPI doesn't say this is what the measures are that you must take. So it's often a commercial decision about what you think is appropriate.
Okay. And then in the industry, in past, we used to turn around and have paper, all our files were paper, and we've now gone on to a paperless system. But some of the paper documents we had to keep for a number of years, which now we may destroy. Is there a certain way that they need to go about destroying them?
Yeah, so absolutely. So destruction needs to be done securely. I mean, there's this classic case in the US with all these war vets. Medical information was thrown away in clear plastic bags. That is not a secure way to destroy personal information. So we'd recommend that it be done by sort of a confidential shredding company, or actually, you know, burned or whatever it is with paper records. So one would just need to be very careful if you outsource that to make sure that you have an agreement in place with that third party. Because if that information doesn't get destroyed as it is supposed to and ends up somewhere else, you're still going to be responsible for that. So definitely, you know, I mean, the companies that specialize in kind of secure destruction of information. If you're not comfortable with you know, outsourcing it, you know, just make sure that you do it yourself. And it's much easier to destroy paper documents than it is electronic. So get creative and have a bonfire.
Rick has asked another question. Would our request for an existing policy schedule to be an example of a data subject request?
Sorry, I don't think I understand that. What is the...
Would a request...
Oh, no. So that wouldn't. So a data subject request, there are very specific rights that are set out. And when it comes to getting a copy of the information that someone holds about someone, there's a specific form in POPIA that needs to be completed. So when someone asks for a copy of their policy, that's not, I mean, that's just in terms of your contract. They're just requesting a copy of their policy. That's not a full set of all the information that you have about them. They can, of course, use that information when they get that and say, look, I'm not comfortable with you processing X, Y, and Z. And then you would say, well, we can't give you insurance, or whatever, you know, answer might come in. But there are specific formal data subject access requests. So I wouldn't consider that to be one of them.
Okay. And then last question from my side. I see that POPI, and it's quite a big thing on a lot of the brokers have sectional title policies that they look after. POPI affects the community schemes as well, which I don't know if everybody is aware of it, and they also have to have their officers in place.
Yeah, so it affects everyone. And I think, you know, that's the challenge is there's no threshold. You know, you process, if you are sort of, you know, unless it's for purely personal or domestic purposes, you know, if you are processing personal information related to a function of a body, that is going to be covered by POPI. So absolutely, actually, we're dealing with a number of, I think people were desperately waiting to complain as soon as POPI came into force. But certainly, you know, all sorts of body corporate, sectional title schemes, everything, particularly in circumstances where people are doing rates on behalf of others, you know, obtaining insurance on behalf, all of those sorts of things. It's really important to think about that. Access to complexes, you know, these are a lot of things that certainly trigger it. And there's no one, you know, if you're providing a service or doing something for people, you have to comply with POPI. And the fact is, even if you don't register your information officer, your default is the head of the organization. So they've already got that liability. And if they, whether they register or not.
So would it, in that case, would it be the managing agent that would be the head of that thing, or would it be a trustee? Probably
a trustee, I think. Because it's the equivalent of the CEO or MD.
Wow.
Yeah. Okay, so lovely. That's something to think about.
Absolutely. Thank you so much. Sorry, there is one more. Lloyd Barker has asked, how does one deal with information between the insurer broker and a vehicle tracking company, whereby the risk item is shared?
So, I mean, you would have to look at exactly what information is being processed by whom and where it is collected and who defines what needs to be processed. So, you know, so you always need to be thinking is, are they processing it on my behalf, or are they doing it in order to perform a service? So, you know, the tracking company, for example, needs that information that is transmitted from the tracking device in order to perform its services. It's not going to get that from the insurer. Yeah, it's a bit of a difficult one. You're going to have to look at the flow. I mean, my opinion is that I think in many circumstances, the broker and the insurer will be a joint responsible party, because the broker will have a separate relationship with the insured. They would have collected that information. They'll determine how they use and process it. But, you know, if the insurer says to the broker, I'm processing a claim, you must go and collect X, Y, and Z from your insured, they might be acting as an operator in that sort of limited window. So it's a bit hard to say in a general point, but certainly the parties should have an understanding of who's fulfilling which role in those circumstances, and the agreements between the parties should regulate that, particularly if there is any processing on behalf of one another.
Okay, lovely. Thank you, Ross. We've actually gone over time, and thank you so much. It's been a very informative session. I think everyone's very scared, very skeptical. But I'm sure we'll only see the impacts of it once claims start coming through and we're having to deal with them.
Yeah. So it is, I mean, certainly when we take from the European experience, there was a massive flurry in the beginning with everyone exactly as it was here, except their WhatsApp groups weren't affected. So everyone sent out all these notices and all the rest of it. And it kind of settles, of course, until someone in your industry gets a penalty. And then you know, and obviously you guys also have very active sector regulators who are very interested in protecting insured's information. So it's definitely something that you have to take very seriously. And I mean, certainly the cyber risk, I mean, in South Africa, you know, it's ironic because, you know, they're talking about safe destinations in other jurisdictions. I mean, South Africa is really not a very secure jurisdiction for data. So we do need to take more measures than we might in another place.
Great, lovely. Thank you so much. Thanks for the time.